Well, good. Still good morning. I'll be doing a briefing tomorrow at 12:30 in the press room, and we'll answer more questions about particularly the work of the Office of the Prosecutor, the progress of the Charles Taylor trial. But we did want to provide a brief opportunity while the President was still here if there are any questions. So if you have any, we'll answer them.
Sure. What's the number of witnesses that Charles that are going to be allowed in the course of the defense?
This is something only the presiding judge can answer, because it's up to the presiding judge and the judges of the trial chamber to see if there are double witnesses not necessary, and so on. It cannot be predicted. It cannot be predicted either by the prosecutor nor by the president.
But before I do that, it's not uncommon to have the defense list a great many witnesses. In the CISE case, the interim leader of the RUF that was the leading accused in the RUF trial that we had the judgment on in February, his counsel had listed about 330 witnesses and in fact called 59. And that wasn't, there really wasn't any specific action by the trial chamber to limit witnesses, and the trial chamber does have that power as to both the prosecution and defense. The defense has said that they anticipate calling far fewer than the group that they listed. So we're just going to have to wait and see.
But has the office, as a prosecutor, have you opposed that number of witnesses?
Well, we think that the witness list is too long. The summaries are not complete. A great many of the predicted testimonies are repetitive, and we will be at appropriate times asking that it be limited, keeping in mind, of course, Charles Taylor's right to contest the indictment and to raise non-repetitive testimony that's relevant to the case.
And the missing indictee, or perhaps dead indictee, Johnny Paul Corona, what procedure are you going to use to sort of either close that out, or?
Well, there are two potential proceedings. One would, which is under discussion at the moment, is that there would be some kind of internationalized chamber established in Sierra Leone that could try his case afterwards within the context of the Sierra Leone justice system. That's a bit complicated because of the Leone amnesty, which might apply to a case that goes forward within that national system, and that issue we're looking at the moment. If that does not work, then the options are similar to the options that have been taken by the ICTY and ICTR to move for transfer to a national court under the context of the rule that permits such transfers if approved by the judges. There's a Rule 11 bis, so-called, that's a rule, a very similar rule at each of these courts, Yugoslavia, Rwanda, and Sierra Leone. And we would then be, as I said, we're in discussions with two states whose identities we won't disclose, but that would have jurisdiction to pursue the case to determine if they were willing, and we could then proceed with an application to transfer the case to them, which would have the effect that if Johnny Paul Corona were to surface after 2011, that our arrest warrant would work in that state's favor, and that he would then be transferred to that state to have a trial. But of course, that trial would have to be one consistent with due process and international standards. And so, but those questions would be determined by the judges once we file the motion.
That will be part of the residual mechanisms we have to establish.
Yes.
The press has sort of focused on Taylor's acknowledgement that he permitted the use of skulls and roadblocks to sort of send a message. Do you think that has any kind of probative value in terms of what you charged him with? And two, do you think the press is sort of focusing on a gruesome detail rather than what would you have the press focus on other than skulls?
Well, we want understand. I'm not going to comment on testimony that he's giving that the judges will weigh up. We're not permitted to comment on things that are under judicial consideration, as we say, sub judice. We did respond to some of the statements that were made by the defense attorney in his opening statement that were really outside the trial, that sort of raised kind of political issues, and we'll be glad to respond to those. Obviously, our case does allege that Charles Taylor was responsible for crimes of terror and gruesome display of human remains, etc., could be part of that kind of terror. but I'll only deal with that from the point of view of what's in our indictment. And obviously, once he's concluded his direct examination, our team, led by Principal Trial Attorney Brenda Harris, is ready and able to cross-examine him extensively on everything that he said. Keep in mind that he is testifying to a lot of things that go outside the temporal jurisdiction of the court. He's been talking about a lot of things that happened well before the events in Sierra Leone that are of relevance to our trial. But of course, issues of his credibility are very much at stake, and so that we may be cross-examining him on things that go outside the direct jurisdiction of the court, because they'll bear on his general credibility.
So, with the prosecutor in line for a new job, what's the procedure going to be to find a new prosecutor? How long will it take? Will there be any time that there wouldn't be a prosecutor?
I can assure you that there will be no whatsoever interruption. We cannot afford any interruption, and we will not have one. Provisions have been made. There will be a follow-up person, of course, because we need one. And in the meantime, we have an interim. We have interim procedures, but in any case, concerning the trial of Charles Taylor, there is a very capable, as you have said, a very capable trial attorney who will continue.
And let me just say in that regard, though I'm not to comment on anything about my future position if I'm confirmed by the Senate to be Ambassador at Large for War Crimes. But if I'm confirmed, then I'll focus on the departure from the special court, determine how much notice I need to provide, and be assured that everything is well in hand before I step down from that position. My term I was appointed in December of 2006 for a 3-year term up to the end of December 2009. I may well be leaving before that time, but if I do, it'll be in the assurance that others can handle it. And in regard to the Taylor case, I have given the opening and led 2 of the witnesses, but it had not been our plan for me to cross-examine Taylor or the other defense witnesses. And as I said, we have a very able team led by Brenda Hollis, who was the senior trial attorney that won the first trial at the International Criminal Tribunal for Yugoslavia, the Tadic case, and a very good team with her that will be able to complete this trial along the lines of the strategy that we've jointly developed.
You probably, this will be the last one. You may not answer this one yet. As an expert in all these things, albeit a cautious one, the Truth and Reconciliation Commission has made this recommendation about President Johnson's survey. Due to what they say was support of Charles Taylor, she should be barred from public life for 30 years. I understand it's a very political question, but what do you think? What would support, economic support for Charles Taylor in the time that it's alleged? What would it mean? How would it make you feel as the prosecutor of Charles Taylor?
Well, we don't, I've spent a fair amount of time in Liberia explaining our trial, and people periodically ask me questions about crimes in Liberia and what Liberia should do about them. And I'm always very careful to say, whatever happened in Liberia, crimes or any other acts, those are decisions for the people of Liberia. And I don't get involved in that. I get involved in our case, which is the trial of Charles Taylor for allegations that he committed crimes or was responsible for crimes in Sierra Leone. And so I'm not going to enter into to anything in regard to the TRC, whether it's criminal prosecution or lustration or whatever, though of course it is to be borne in mind that those are recommendations, and before any of them are implemented, there would have to be action